Sheehan part or anybody who supports this legislation. I don't think people are trying to water anything down or destroy the Ethics Commission in any sense. And I understand that these are disagreements about language. But I still think that language is incredibly important, and that if we don't get it right, we're going to end up in litigation over its lack of clarity. And so I'll just finish my point about this phrase, criminal in nature at common law. No one I know can point to which parts of the Code of Ethics as they exist in law today and say which parts are criminal and which parts are civil, right? And I put that question to many good attorneys, and I put it to many folks who know the Code of Ethics much better than I. And so how is the Ethics Commission expected?
Let me just cut you off for 1 second, just say anecdotally. Yeah, well, we certainly wouldn't want to confuse that issue by putting everything under one house, right? Under one house of oversight. I mean, fundamentally, isn't it a violation of the separation of powers when you have the legislative branch, the enforcement branch, and the judicial branch all sitting under one roof? You can go on. That just comes to me intuitively.
Okay, and there's one of the interesting things about the history of the Ethics Commission is, a lot of these issues have come up before, and if you look at some of the advisory opinions that came out early in its existence back in the early 90s, they talk about, is it a fourth branch of government? And they talk about some of the issues that you raised, Senator Archambault. And if you haven't had a chance to look at those lately, I think you should, because I find them refreshing every time I look at them. I don't want to go on, but we believe that the simple approach that we've been proposing for 7 years is the right approach. We think that the court identified a problem that exists because two parts of the Constitution were, in their opinion, in conflict. We think the simple solution to that problem is to give the people of Rhode Island, and remember, it's not your judgment or my judgment. Ultimately, this goes to the people on the ballot. It's their judgment, and we think they should be given a very simple question about restoring the full jurisdiction of the commission, nothing more, nothing less. So I'll leave it there.
Again, I'm sorry.
Mr. Marion, I just have a quick question for you, and that is, and this question may be better served to Mr. Grammett, but and I vaguely remember us discussing this last year, but are there any requirements or qualifications for members of the Ethics Commission? So there are, there's 2 points I'd like to make on that. There's a statute that has been passed by the Assembly that actually disqualifies certain people. Right, so it disqualifies people who are lobbyists or whose law firms derive income from lobbying, and it puts some other qualifications. So there isn't, in the sense that the Judicial Nominating Commission has to contain a certain number of lawyers. It's not required that there be a certain number of lawyers on the Ethics Commission, or doctors, or nuns. Evidently, there have been 2 nuns on recently, but rather it's told who can't be on the Ethics Commission. And the other point is that when we talk about separation of powers, the Ethics Commission is appointed by the governor, but roughly half the picks come from the legislative leaders. It's really a commingling of those 2 branches of government in that sense. And that's, it's, the Ethics Commission stands outside of other commissions that are governed by the separation of powers that passed in 2004 in many senses, because it is named elsewhere in the Constitution. But there's no I guess, set of qualifications. Like, it only says who can't be on it, not necessarily what type of qualifications that they would need to be on it. No. Any specified knowledge of ethics or administrative procedure or anything like that?
I defer to Mr. Grammett. I think there is language of, there are some nice adjectives in the statute about looking for honest people, but I can't cite it off the top of my head.
Thank you. Senator Lombardi and then Senator Archambault.
Thank you. John, and I hate to keep going back and forth. I know how Senator Lynch hates when I talk. But You just used the word full jurisdiction of the Ethics Commission. I take it you mean that Senator Sheehan's bill falls short of full jurisdiction as it relates to the speech and debate clause, but not as it relates to a trial by jury.
Yeah,
issue.
I was referring to speech and debate.
Okay, and you understand that, as the way I read Senator Sheehan's bill, that the fact that the statute says what it may say does not prevent the Ethics Commission from bringing forth a complaint if it believes it does not come within that exception. You understand what I mean? What I'm saying to you is there's nothing respectfully, I disagree. I think both bills restore full jurisdiction to the Ethics Commission. I believe that there may be some issues that may not be in the four roles that they play presentable or prosecutorial or can be brought forth by virtue of the speech and debate language in Senator Sheehan's bill. But I don't think, again, I don't think Senator Sheehan intended to limit the jurisdiction of the Ethics Commission. The Ethics Commission is free to bring forth any violation it deems to be a violation of the Code of Ethics. How that plays itself out in a litigation sense initially at the Ethics Commission and subsequently on an appeal is for a later determination.
But actually, I would disagree because if 2427 became was put into the Constitution, I think the Ethics Commission would be limited to bringing or to accepting and then going forward with complaints with respect to certain actions, parts of the so-called core legislative acts that the Rhode Island Supreme Court talked about that include speaking, voting, and I'm not saying his would exclude voting, but I'm trying to define what some of these core legislative acts are, but influencing legislation. And we don't know with his language what the court's going to read into that phrase about discussion as influencing what of the core legislative acts fall under that exemption.
Precisely my point. You don't know what the courts will say. If they mean that the court at a later date may say, look, this comes with full jurisdiction versus something less than full jurisdiction. I think both of these bills get there. I think it's a question of what happens, and that's why, I think why the appeal right is so important. Because I think in the first instance, the Ethics Commission can bring forth its complaint under the Sheehan bill or under the O'Neill bill. What happens at that point, after the Ethics Commission has acted, depends on the courts at that point. Or under the O'Neill bill, it's over. But in the Sheehan bill, it depends on the courts at that point, based on an appeal and a right to a trial by jury, or a decision by a judge as a matter of law that this is not an ethics violation. But again, Jen, I hate to keep using it, but she's sitting right there, and I don't want anyone to think that we're somehow trying to, at least me, I don't need to speak for anybody here, at least me, I'm not looking to limit the jurisdiction over me and what I do. Not at all. I'm all for the jurisdiction over me and what I do. I've chosen, unlike this young lady in the middle, I've chosen to run for office, and with that comes the rights and privileges that I've yet to see, but the consequences as well. And those consequences are that if I run amok of my power, I'm subject to this jurisdiction, and I'm accepting that. All I'm saying is that, you know what? You're not always right, John, and I'm not always right. Let's go to a neutral arbiter, the courts, to determine who's really right in this case, and that's all I'm saying. And clouded in that was when Mr. Block, not quoting, but clouded is, people believe that the judges are in our pocket. That's an absurdity. But the basis of it is, I think we all want full jurisdiction. It's just a question of where we get the finality of that jurisdiction.
John, that's enough.
Senator Archambault.
So amplifying for a second on what Senator Lombardi just said about the safeguards, the inherent safeguards within our U.S. Constitution and our state constitution of the separation of powers doctrine. When you say, and it's certainly not the first time I've heard it, the buzzword fourth branch of government, I shudder. And I think to myself, wow, that's why I'm more in favor of Senator Sheehan's bill than I am in terms of being in favor of Senator O'Neill's bill. I think that the Ethics Commission is the noblest of watchdogs, imbued with the spirit of the people of Rhode Island, to keep a check and balance on all branches of government. I think the work that they do is incredibly important and incredibly laudable, and it shouldn't be undermined. At the same time, after findings are made, we should have faith in our judicial branch, particularly if there are criminal charges, that the adversarial system that was created at the founding of our great nation and that our Rhode Island citizens adopted in their Constitution will work. And to suggest that we should have one branch of government have unbridled discretion, and to, frankly, say that the people in 1986 basically in this state dealt in great depth with and answered the questions raised by the ACLU, and so aptly pointed out by Senator Metz in the third paragraph of the ACLU's letter, I think is, again, and I'm trying to be kind, John, because I respect you so much, but I think it's a gross misrepresentation of what the intent of the Ethics Commission should be when it comes to oversight of the General Assembly and any other branch of government in the state of Rhode Island. So I certainly don't think it should be characterized as a fourth branch of government. I think it should be something that works in concert with our U.S. Constitution, our state constitution. And Senator Connolly can speak to greater depth on it, and as he gave us a great brief here that points out in great detail what his thoughts are that he's pointed out already. But I can't sit here and let that go unnoted. And while we were talking, I looked up something I have to say. You've all heard, I'm sure, of Alex de Tocqueville and Democracy in America. If it be admitted that a man possessing absolute power may misuse that power by wronging his adversaries, why should not a majority be liable to the same reproach? Men do not change their characters by uniting with one another, nor does their patience in the presence of obstacles increase with their strength. For my own part, I cannot believe it. The power to do everything, which I should refuse to one of my equals, I will never grant to any number of them. Alex de Tocqueville. That's the spirit that our founding fathers have in the Constitution. Of course, John Stuart Mill and other people. But you get the point. You get the point.
I get your point, Senator. I'll make one last response, which is that remember how this all started. Senator Irons took his case to the Rhode Island Supreme Court. He had his right, his day in court. He had his day in Superior Court. He had his day in the Supreme Court. And I was there when Senator Connolly was there, and it was quite a spirited discussion. It was a great discussion. I was fairly new to the job. I learned a lot that day, and things that I still carry with me to this day. And so we're not, I don't want to be painted as we're extremists. We're not trying to take away anybody's right, as it already exists, to appeal a finding by the Ethics Commission against them. We are talking about something very different, which is changing the nature of that appeal.
Senator Connolly.
What's the standard on appeal?
It's an administrative appeal.
And what's the standard?
So I can't recite the part of the Administrative Procedures Act from memory.
No, I'm not asking you to recite the act. I'm asking you what the standard of review is on appeal. In other words, when it goes to Superior Court, you just said that, well, they've got the right to appeal. So let's talk about what that right to appeal is. It's an administrative appeal, correct?
Mm-hmm. Correct.
Okay. When it goes to the court, what is the standard of appeal?
I know, and again, not being an attorney, I can say that they can appeal on matters of law, but not on matters of fact.
Now, the standard on appeal.
Continue, Senator.
The standard on appeal is whether or not the evidence brought before the administrative board is based on more than a mere scintilla. Now, I'm not sure I know what a scintilla is, but I know I do not want my guilt or innocence to be riding on the standard of whether or not the evidence amounted to more than a mere scintilla. In a jury trial, the evidence is beyond a reasonable doubt. If I am accused of violating the code of ethics, a matter that is a crime at common law, and I'll address that later, I do not want my guilt or innocence, and I don't want the guilt or innocence of any fellow citizen to be decided by the standard of whether or not the evidence was more than a mere scintilla. I want it to be decided by what my Constitution says I have a right to. And I want my fellow citizens to have their guilt or innocence decided by what our Constitution says they have a right to. And our Constitution says that they have a right to have their guilt or innocence decided by evidence beyond a reasonable doubt. Mere scintilla, beyond a reasonable doubt. What do Americans deserve?
Thank you. The next group of witnesses we'll call are H. Philip West, Bill Felkner, Terry Givians, Sam Bell. Oh.
Thank you very much, Madam Chair. Members of the committee, thanks for your patience tonight. It's been a long night already, and I think you still have more witnesses to go, so it may be a while. I do want to, since Senator Lenahan's name has been mentioned several times tonight, remind everybody that we are approaching the first anniversary of his death, 27th of February last year, probably one of the most honorable people that any of us have ever known in any part of our life. An amazing person. I want to give the clerk a statement, if I may. This is from Ray Condon, who served as the first, as the director of the Conflict of Interest Commission for 10 years, from 1976, actually more than that, till the beginning of '87. And it's her comment. I'm not going to read it. You'll have it. But her simple summary of these two bills is, I'm just going to read two sentences. 2427 is not a remedy and would invite more litigation, further eroding public trust. Passage of 2060 is a clarification which would be an important first step toward restoring public confidence in the General Assembly and its important work. Ray Condon later served as on the Common Cause Board. She was my mentor in 1988 when I began to write at the direction of the Common Cause Board a complaint against Governor DePrete. And she guided that process, and I learned a great deal from her, and I would recommend her to you. I want to thank Senator Sheehan, still here. I don't know if Senator O'Neill is still here, too. These guys have really been patient over a long period of time. I favor Senator O'Neill's 2060, which is before you, and I'm going to make some comments in support of parts of Senator Sheehan's and to disagree with parts of Senator Sheehan's bill. I should say at the outset, while I served for 18 years as director of Common Cause Rhode Island, I'm not representing Common Cause on this. I am speaking for myself. I have not met with the board about it. I'm speaking for myself. As Senator Sheehan has already indicated, a group of us, including himself and Senator Conway, Jason Grammett, John Marion, and myself, and for one meeting, Senator O'Neill, had a number of conversations after the hearing in this room last April. Since those meetings, I've done some research, and I want to focus on part of 2427, part that will work and part that I think will not work. First of all, I'll start with what I think will work. I'm going to disagree at this point with John Marion. I think that the public forum exception probably will work, and is not, in my view, not the kind of thing that's going to cause major problems. I would call your attention, and I won't read it now, to the Ethics Commission's regulation 3614.8001, which Senator Conway knows well, which is the public forum exception, which people have referred to several times. It essentially permits any public official to express his or her views in any public forum on any matter of general interest. And the issue is taking an action, voting, or letting a contract or something like that. But the public expression is there. And I would say it's there even if we did not do this language that the group that Senator Sheehan referred to added on page 2, lines 17 and following, provided, however, that members shall be free without question to engage in public discussion prior to any vote on the floor of the House of Representatives or the Senate or in committees thereof. I personally think that this language probably makes sense and is a help in the sense of making clear that you may get charged for core legislative acts, for the backstage things, the things that are in secret, the killing of bills for pharmacy freedom of choice, which Senator Irons and Senator Salona and former House Majority Leader Jerry Martineau all were involved in doing. And that's what Irons is protected, even in those kind of actions, and that's wrong. And so you need to pass this to restore that jurisdiction and recognize that. But in any event, I'm not as troubled by that language. I think that's reasonable language. I would go further in on Article 3, Section 9, at the top of the page there, the Ethics Commission composition. And I'd like to speak to that for a minute, because that basically has already been explained, and I won't go over it again, but I'll be glad to talk about it if you wish. It addresses the question of putting the appointment of the Ethics Commission into the Constitution. Now, again, some may think that's neither necessary nor appropriate. I had a conversation with the Senate President shortly before I retired in 2006, when she was then Majority Leader of the Senate, and she expressed concern that a future court, based on the Separation of Powers Amendment of 2004, might overrule the appointment scheme. I think that's an important question that she raised with me at that time. And so I would point out to you that in article, that section starts by saying, except that they would not be, I'm sorry, I'm in the wrong place. Notwithstanding Article 9, Section 5, which is the appointments clause of the Separation of Powers Amendment enacted by the voters 78% in 2004, it goes ahead, in other words, notwithstanding that requirement that the governor appoint all members of any board or commission that exercises executive powers in the state of Rhode Island, and the Ethics Commission clearly executes executive powers, this is how the appointment will be done. So it clearly is carving out to say the separation of powers can't be used to wipe out this merged identity of the Ethics Commission which is recommended by members of the legislature. 5 come from legislative nominations. 4 come from the governor without a nomination. I would point out to you that for a long time there has been a struggle between the House and Senate regarding balance on the Joint Committee on Legislative Services. When we drafted the statute establishing the Judicial Nominating Commission, we used a 9-person model where there would be the Senate President, eventually, then the Senate Majority Leader, and the Speaker would share one nomination. And that's the model that this follows. So you're talking about 9 members. And here's the important point. This is not a rogue body. This is a body which has been appointed by people who have been vetted by leaders of the legislature and by the governor's office. They're not going to go off on some haywire kind of process, and I think that's clear. So unless there are questions about this specific thing, I'd like to leave that question of appointments, but I think this would be a good thing to put in the Constitution. I believe that it answers the question that the current Senate President raised 10 years ago. It's appropriate. Now I want to go to the criminal in nature at common law section, which is Article 3, Section 8. Provided that any person against whom this commission finds a violation of the code for any conduct that was criminal in nature shall be entitled to a trial by jury. Senator Connolly and I sat closer to each other in the process of trying to hash out this language than we're sitting tonight. At the time that we did that, it made sense to me. Since then, I've done some research also, and I've come to think that it is difficult language. First of all, I've looked at other states, all of which talk about this appeal process in statute rather than in their constitutions. 11 states, and I can give you the list if you wish, allow a de novo appeal from the findings of an ethics commission. 24 states, including Rhode Island currently, do not have the de novo appeal, and I can give you that list if you wish. I haven't found any states, and I won't claim that I've gone through all the state constitutions yet, but I have not found one state constitution that puts the jury trial appeal from an ethics commission finding into a constitution. And that's where I want to raise a question. I had worked on this, and I found myself getting more and more into the weeds and more feeling like the language that we thought we had agreed on in Senator Sheehan's office was a confusing place. And so I asked some people that I considered competent and expert and more knowledgeable than I am on the law. And the first person I reached out to was Patrick Connolly, who is state historian laureate, but has written the book on constitutional law in Rhode Island. And I I'm just going to read one sentence from his sentence to me. To look for an act that was criminal in nature at common law is meaningless. It is like looking for a needle in a haystack. In 2011, a study in England of the common law concluded that there were more than 10,000 offenses, excluding those created by law. He goes on and he says, I would not pursue that language. It should be deleted as meaningless. I think if there's anybody who's an expert on constitutional law in Rhode Island, it's Pat Connolly, and that's his position.
Senator Connolly.
Thank you, Madam Chair. Pat Connolly's no relation, so I want to get that right out there. And I respect his prowess as a lawyer and history and historian and real estate developer and everything else that Patrick does, but I'm really going to be forced to disagree with him. And I apologize somewhat for the length of this response, but I think the fact that there's been some authority cited for the proposition that that's a problem needs a response on the record so that you all feel that there is a very strong basis for Senator Sheehan's reliance on that language. Now, we've talked about the right to a jury trial. I'm going to reserve why these acts, which were criminal in nature at common law, deserve a jury, a constitutionally required to get a jury trial, and just direct my comments to the focus of your reference to Professor Conley's comments. And I'm sure I'm not the same quality of constitutional lawyer that he is, but I'm going to do the best I can. The genesis of that inquiry, what is a crime at common law, begins with our own Supreme Court. And I'm going to quote from a case, and so that all of you fact checkers can do, I'm going to give you the exact page and site that it comes from. In assessing whether a particular cause of action merits a jury trial, we look to the historical nature of the claim, tracing its origins and striving to discern analogies to forms of action known to common law. And our Supreme Court told us that in the case of DePardo and Sons, Inc. versus Fazan at 708 A. 2nd 165, a 1998 decision of our court. Our Supreme Court has held in more than one case that a jury trial is available for all violations that were considered criminal in nature before 1843, because 1843 is the date that our Constitution came into effect. And the cites for that language from our Supreme Court are Fudds, Inc. versus the state, 727 A. 2nd 692, at page 695, a 1999 decision of our Supreme Court, and State versus Vinagro, 433 A. 2nd 945, at page 947, a 1981 decision of our Supreme Court. So to repeat, in each one of those cases, our Supreme Court, the Rhode Island Supreme Court, interpreting the Rhode Island Constitution, has told us that a jury trial is available for all violations that were considered criminal in nature prior to 1843, because 1843 is when our Constitution came into effect, and our Constitution says that the right to a jury trial shall remain inviolate. In other words, you can't take it away. Now, to the question of, well, what was criminal at common law? There's really an ample history that claims of alleged misconduct of public officials were recognized and existed at common law, and that such violations were considered criminal in nature. Where does that information come from? Well, I'll cite to you, first of all, an authoritative text called Archibald's Pleading, Evidence and Practice in Criminal Cases, 23rd edition from 1905. Misconduct, fraud, and oppression by officers of the Crown is indictable at common law. I'm going to get into some of those specifics, but you can also look to T.W. Hughes, A Treatise on Criminal Law and Procedure, section 615, at page 414, and that's a 1919 publication, which points out to us that official misconduct, which is indictable at common law, consists of malfeasance or nonfeasance in office. So I guess I'd ask the question, well, what was malfeasance and what was nonfeasance? Well, under English law, and by the way, that's where our common law comes from. We've used the word common law a lot. Common law is actually the foundation of the development of all of our law that we inherited from Great Britain, came over as colonies, have used in our court system since the Revolution, and continue to use it today. That's what the common law is. We are a system of stare decisis, meaning that each court decision is based on precedent from prior decisions that build and create the common law. Now, so we have to look all the way back to American Revolution, pre-federal Constitution, to see if there's any common law that supports the language in Senator Sheehan's bill. Criminal in nature at common law. Words from our Rhode Island Supreme Court, by the way. Senator Sheehan and I didn't make those words up. We took them from our Rhode Island Supreme Court because it has interpreted our Constitution. Now, under English law, misconduct or misfeasance in public office was an offense at common law that dates back to the 13th century. I have in the papers I've provided to my colleagues on the committee, I gave you a website that gets you to several publications that deal with it, and it brings you to essentially a service known as the Crown Prosecution Service, which is a compendium of cases from Great Britain. But I would also commend to your reading in a more general address of it, the text of Corruption and Misuse of Public Office by Nichols, Daniel, Baccaris, and Hatchard, the second edition of the Oxford University Press, published in 2011. Now, courts have looked at all of that precedent, not just our court. So I don't want you to think that Rhode Island Supreme Court is an outlier on this. It's not. In fact, it's in the mainstream. In Latour versus Stone, a case coming out of the state of Florida, a 1979 case, that court recognized that malfeasance and misconduct by a public official were criminally actionable going back to the common law of England well before 1843, the start date for the Rhode Island Constitution. In this regard, the Latour court acknowledged the English common law rule that, quote, any public officer is guilty of a common law misdemeanor who commits a breach of trust, fraud, or imposition in a manner affecting the public. Now, within that case, I want to tell you who they cited, and you can go back and look at their original source documentation as well. They were quoting the laws of England from the Earl of Halsbury, an educated man of his day, Volume 9 of Criminal Law and Procedure. Also, the Common Law of England, W. Ogden's Volume 1, Stephen's Commentaries on the Law of England, 15th edition, Volume 4, 16 C.J. Criminal Law, Section 23. Now, what all of those flow from is all those compendium of cases that I just referenced to you from the Crown Prosecution Service. And if you look there, what they tell you is that this offense, which goes back to the 1200s, they can even tell you the elements of it. You don't even have to guess. No conjecture, no speculation, certainty. These are the elements. A public officer acting in his capacity as a public officer. Secondly, willfully neglects to perform his duty or willfully misconducts himself. And it's in English, so it's he or she's, but in the Old English text they just use the masculine pronoun. Thirdly, to such a degree as to amount to an abuse of the public's trust in the office holder. Fourth element, without reasonable excuse or justification. Now, by the way, a lot of our common law comes from old acts of parliament that are handed down to us in the common law. And particularly with relation to those four elements of that common law offense of misconduct in public office, whether you characterize it as misfeasance, malfeasance, or nonfeasance, that goes back to the first statute of Westminster, 8 Edward 1, Chapter 26. And you can see there, if you look at that in 1275, one of the cases was that it was a criminal act for a public official to take a reward to perform one of his official duties. In 1818, a public officer was deemed to have committed a misdemeanor if he committed fraud or breach of trust affecting the public interest. Now, that site is also within that state I'm sorry, another case. But I want to make sure that the references are complete. That 1818 case is Regina versus Massarone. And it's cited in Ogders versus Ogders at that same text I cited earlier. And I can see I'm losing my audience, but I'm going to finish. Now, another case to show you that we're not an outlier, that other states have adopted the same process, is the state of New Jersey. State versus Thompson, 953, a second 491 at page 499. It's a 2008 case. The Thompson court explained that under the common law, official misconduct included any act which is wrongful in itself, that's the malfeasance, any lawful act performed in an unlawful manner, that's the misfeasance, or omission to do any act which is required of him by the duties of his office, nonfeasance. And for other cases following that precedent, I'll cite to you State versus Hines, 674 A. 2nd, 161 at page 163, and State versus Majorana, 542, Atlantic 2nd, 510 at page 12, page 512. Now, to show you, and again, I apologize for the length, but since it's been said that there's nothing out there in support of this, I think it's important that we make the record abundantly clear. Other courts have also recognized that common law offenses for unlawful conduct by public officials included neglect of duty. Donnelly versus United States, 276 U.S. 505 at 516, it's a 1928 case. And the violation of duty to disclose a conflict of interest. United States versus Sawyer, 239 Fed 3rd 31 at page 49. Our own First Circuit case, 2001 decision. So based on all those authorities and the analysis provided in there, I think it's really clear that a charge of a conflict of interest, misconduct in public office, was actionable at common law, and each was considered criminal in nature. Now, it was asked earlier, who can tell us that, if you keep that in there, who can tell us what under the Code of Ethics would be included in that? Well, I want to begin by saying that codifying an offense that was criminal in nature at common law and now labeling that defense an ethics violation does not transform that new statutory creation, that new statutory violation, in such a way that it eliminates its character in the common law or strips that person of their constitutional right to a trial by jury. If that were the case, if you could just put it in a statute and change the name, then there'd be a wide assortment of crimes, violations, that you could just put in the general laws and say, okay, you're not entitled to a trial by jury. Now, let's look then at how does that analysis apply to our ethics code? Because I would suggest to you that there can be no doubt that misconduct by a public official is criminal in nature at common law. The words are well understood, well interpreted since about the 13th century to our current interpretation by cases not just in Rhode Island, but in other states as well. Our Supreme Court, as I know, has observed that the argument that one charged with misconduct by a public official in conflict of interest should be afforded the right to a trial by jury, and that's a formidable one, and I already referenced that before. But in the package that I gave you, if you go to the next tab, tab 3, you'll see that I've attached the Rhode Island Ethics Code Prohibited Acts section, 36-14-5. Now, I'm not going to read the entire statute to you, but without reviewing it in every section, it's readily apparent that those sections which would address members of the General Assembly are codifications of misconduct in public office, are codifications of a betrayal of the public trust and acts against the public interest. Whether you characterize it as misfeasance, malfeasance, or nonfeasance, each would have been a crime at common law. The chapter is replete with prohibitions against conduct in conflict with the proper discharge of duties or against the public interest, crimes at common law. Now, trial by jury is a fundamental democratic principle of the American system of jurisprudence. It guarantees us, it guarantees you, it guarantees all of our citizens that an accused will be heard and judged by fellow citizens. So frankly, the idea that, well, the judges, they're former legislators, or the system for picking judges isn't ideal. It's not about the judges. It misses the point. It's about the right to be tried by your fellow citizens. It's the right to have your guilt or innocence decided by your citizens. It guarantees Americans that citizens will be the final arbiter of guilt or innocence when the power and the authority of the government is brought to bear against an accused. Right now, we have an agency that does it all. It investigates, it prosecutes, and it's the judge and jury. And the appeal that was referenced before, remember, your appeal is only whether or not the evidence was more than a mere scintilla. Appeal by jury trial means you get the same right as every other American citizen to have your guilt decided by your peers. It guarantees that the most fundamental democratic element of the American system of jurisprudence, the trial by jury, is not taken away from any citizen. Frankly, we do have certain privileges. It is a blessing to be able to serve in the General Assembly, but when we walked through those doors, we didn't give up our constitutional rights. We came here to fight for them and to protect them, not to see them watered down. I guess I got preachy at the end. I apologize for that.
If I may go back to my testimony, Senator?
But when I finish. But when we restore, and again, we have to consider whether or not, our Supreme Court told us that it wasn't there, but for those who take the position, assume that the jurisdiction was there. Now, when this body fights to restore it, fights to bring back that jurisdiction, we can't trample upon the right to a jury trial. Thank you.
Thank you. Are you sure you're done? Okay.
Well,
Mr.
Chair, just one point of clarification. Since we're speaking in terms of transparency, Senator, you did disclaim that Dr. Conley was not related to you. The treatise, the Archibald treatise, has no correlation to Senator Archibald, does it?
They don't even spell it the same.
Okay.
Right under the bus.
Mr. West, please continue.
Thank you, Madam Chair. Senator Conley, I will say well said also. I asked you for those case law right after we worked, and you didn't provide them to me, and it would have saved me some time if you had, and I'm grateful to hear your comments. And I'd like a copy of whatever you've provided to the committee, because that's the only way I can examine it and think about it. But I would welcome a copy of that. I've got some other people who are also legal experts, but the time is very late, so I want to turn the corner not agreeing with all that Senator Conley has said, but I want to make an important point. Article 3, Section 8 already says explicitly that the Ethics Commission shall have authority to investigate violations of the Code of Ethics and to impose penalties as provided by law. And I would simply make a final point and say there is no need to include the jury trial provision in the Constitution when you could set up with more words and with more clarity and with more care through the process by which the Ethics Commission's findings of violation could be specifically appealed to a jury trial and when they should not. I think the concern of the people from the beginning has been that you not open up to a wide open, endless set of litigation. I think it's important for you to recognize that the Constitution provides you. May I finish, please?
Phil, let me just interrupt you for a second, because I know you're well-schooled in your testimony, but it's an inviolate right. And so to say that we're going to simply take that right away because there may be costs associated with it, and that's somehow de minimis to the overall goal that we're going to find the truth, somehow I'm lost there. You know, that defies logic and common sense for me. And Senator Conley did such a brilliant job outlining things, and I respect you greatly for the work you do. I don't say that lightly. Just it's a sacrosanct right, inviolate right, the right to a trial by jury. So the cost associated with it, that'd be analogous to saying the cost associated with appeals in a capital case where somebody's sentenced to death. Well, it's too high of a cost. So, you know, what's one life, right? But certainly, if you were the individual whose life was on the line and you were on death row and you knew you were down to the unholy bewitching hour, you'd want every constitutional safeguard you could get, right? I won't belabor it. You get the point.
Senator and committee, those of you who remain, I would remind you that you can do this by law, and by law you can do it by statute. You can establish the terms and the conditions of any appeal, and you can write that into the ethics code. That's not an unthinkable kind of thing to do. I'm going to end because this has been a long hearing tonight. But
Senator Lombardi.
Bill, I'm sorry to interrupt. Please enlighten me. What is, and I'm perhaps mischaracterizing what you just said, but we just heard Senator Conley so articulately recite 700 years of jurisprudence. But I'm at a loss, quite frankly, and I've asked the question in various forms to various witnesses, and perhaps I need to be a little bit more frank. What is so offensive about the appeal process contained in Senator Sheehan's bill?
I think it is better than where we started. And I have not had a chance to digest Senator Sheehan's presentation tonight, which was lengthy and full of references, which I have not seen.
Well, thank you, because I want to quote not Dr. Conley, but Senator Conley, that we're all here seemingly embracing ethics reform. We're embracing it. And it seems to be that this trial by jury is now becoming the impediment to ethics reform. And I'm troubled by that, quite frankly, because we should be, the way we're embracing ethics reform, we should be embracing that sacrosanct right to a jury. And the gentleman that interviewed me outside a moment ago said, where do you see this going? And I really, I saw, and well, speaking out of turn, but I saw Senator O'Neill, Senator Sheehan, and Jason Graham outside. I really think we're at the threshold of making a giant step in ethics reform in this state. And God forgive us if it's a trial by jury on an appeal that becomes the stumbling block to ethics reform.
Senator,
and I fear that.
Senator, you're making an important point. And I want to remind you that the sub-A that this committee passed in 2014 had a much broader appeal to a jury trial. It was de novo for any violation of the code.
Absolutely.
This is better. This is much, much narrower. I am wanting to read Senator Connolly's argument because I haven't seen all those cases, and my research in terms of what other states do have not convinced me that it's valid. So I'm not going to say on the basis of hearing this in a few minutes tonight that I think he's solved it. I don't think he has. The problem was the way it started in 2014 was a wide open thing that would have invited endless litigation. And I would remind you that Ray Condon, whose experience was as director of the Conflict Commission for 10 years, and Mel Toff, whose comments I did not read to you, but who is a professor at Roger Williams Law of Technical Writing, and others have raised the same concern. I would also remind you that in the course of this debate, all of those speaking so energetically for the jury trial in this particular language have been on that side of the dais, and all of those who have opposed it have been on this side of the dais. I should say, be careful of that because Senator Sheehan sat at this table, so I was wrong about that. But the point, my point would be.
Please let me raise issue.
Finish my point.
No. Please let me raise
Senator
issue
Lombardi.
because I don't think it's a question of opposition, and I warned the folks in this audience about 45 minutes ago that somehow we're creating a schism here. There's no opposition at all. There's common ground. And so I don't want you to say that I don't. First of all, I heard John Marion say that he had no position on Senator Sheehan's bill. Or I'm sorry. I heard Jason Grammett say it. I heard somebody say it here. So there isn't an opposition. It's not an us and them mentality, and I don't want that to happen. And secondly, and please, and I take issue with Ray Condon. I don't know Ray Condon. Apparently, you elevate Ray Condon to a level of extreme importance, and I trust your opinion on that. But what Ray Condon says in this one-page letter is that S-2427 is not a remedy and would invite more litigation, further eroding public trust. I can tell you I strenuously disagree with that statement.
I think I've tried to make clear, and I'll stop with this, that I believe that you can craft a statute that very clearly says whatever you want to say about what the procedures should be for Ethics Commission appeals. I wrote the ethics complaint against Governor Edward Dupree that went before the Ethics Commission, and he was found in violation on 2 matters after the commission itself had dismissed several others. I thought there were others they should have passed, but they didn't. But he was found in violation on 2 matters, and the Supreme Court then overturned one of those. Ironically, we were only dealing with the tip of the iceberg, and as you know, the criminal investigation began, and there was much, much more which was secret, and to which he eventually pled guilty. These are serious matters, and he had his day in court. Almost too many days in court, but there needs to be understanding on both sides of this podium. Thank you.
Thank you, Mr. West. Sir, thank you for waiting so patiently. Good evening and welcome.
Thank you. Senators, thank you for giving me the time to speak. My name is Bill Faulkner. I'm the project coordinator for Clean Rhode Island, the Coalition for Legislative Ethics and Accountability now in Rhode Island. We are a project of the Operation Clean Government Institute, which is the 501c3 arm. And so, as such, I'm not here to support or oppose any specific legislation, but to provide information that I hope helps in your deliberation. Firstly, our coalition is relatively new. We have 18 members so far, hoping to announce a few more next week. But it's a very diverse group. We have the Young Democrats, we have the Progressive Democrats, we have Occupy Providence sitting alongside the East Greenwich Republican Committee, Rhode Islanders for Immigration Law Enforcement, and the Tea Party. We have the Rhode Island Independent Contractors and Associates representing the business community. We have groups like Protecting Families and the Alliance for Safe Communities representing community organizations. So the first point I would like to make is that it's a very diverse coalition. This is not an issue that is partisan. This is not an issue that is relevant to any specific sector. Everyone along this coalition wants to restore the oversight of the General Assembly from the Ethics Commission. I do want to share 2 brief points of research that we have on our website, cleanri.org, and you can always find the data there. The first one is from PricewaterhouseCoopers. People think of them as an accounting firm, but they obviously do a lot more. They did a survey of 390 executives, and I hope this adds a little heft to some of the comments we talked about. This influences the economy. And I'll use my glasses to make sure I get the numbers right. They asked these 390 large corporation executives about issues of corruption. Almost 45% of the respondents said that they have not entered a specific market because of perceived corruption risk. And I emphasize that because it's not always an issue of corruption, but sometimes just a perception that it is there. 39% say they have lost, that their company has lost a bid because of corrupt officials. 65% of respondents believe a level playing field, to your point, Senator, is crucial to the company's future business activities. And this last point, I quote, having an independent anti-corruption program in place is considered valuable or very valuable by 76% of the respondents. So clearly, corruption or even the perception of corruption has a negative impact on the economy, and they strongly believe that an independent oversight of that is a remedy. Now, the next question to ask is there a perception of corruption in Rhode Island? Putting aside the off-the-cuff remarks, I'd like to put some empirical evidence to that. The Gallup poll has a recent study put out on public confidence in state government. The poll found that Rhode Islanders were the second least favorable of their government, second only to Illinois. According to the report, corruption, I quote, corruption and challenging economic times likely contribute to states ranking among the least confident in government. And it goes on to say many of the lower confidence states, which Rhode Island is in, have had a high-ranking elected official convicted of crimes in recent years. And unfortunately, Rhode Island, as we know, fits into that category as well. But oddly, Rhode Island is an outlier. As it goes on in the study, the analysis found a negative correlation between state population size and trust in government, meaning residents in smaller states tend to have a greater confidence in their state government. As a matter of fact, the 10 smallest states in the country have an average confidence level of 64%. In Rhode Island, we're at 33%. So clearly we have some factors that cause us to have a negative result, but statistically we should have a positive result, and so there's clearly something wrong there. So I just kind of want to wrap it up and to say that the interview data from Pricewaterhouse shows that executives avoid markets that they feel there is a corruption risk, and they look for an independent oversight to remedy it. Secondly, Rhode Island ranks very poorly among its residents in terms of confidence in government, in part due to corruption. And finally, Clean RI, the coalition itself, is evidence to show that this is not a partisan issue. It is not a sector issue. Everyone in this state hopes that you guys can make progress on this. So thank you for the time.
Thank you. Any questions or comments for this witness? Thank you. Good evening and welcome.
Thank you. My name is Sam Bell. I represent the Rhode Island Progressive Democrats. We had a debate at our last meeting on whether or not to endorse Senator Sheehan's bill. We were not all in agreement, but a majority of us did vote to endorse it. Although having listened to the debate here, I'm less convinced that that was the right decision than I was at the time. But I don't want to rehash the arguments that have already been given. I want to advance new points I don't think have been brought up. One point I wish to address specifically relates to the language provided, however, that members be free, without question, to engage in public debate prior to any vote on the floor of the House of Representatives or the Senate or in committees thereof. And that creates a right to public debate. And as I read that, and I hope that this is the intent of the legislation, one positive aspect of that is to prevent undue restrictions on public debate. And that, I hope, would have an effect on the rules of both chambers. So what this would do is create a provision where the rules could not be written in a way that unduly restrict public debate. And I think that's a valuable thing to have in the Constitution of the state of Rhode Island, so that the rules cannot be made to quash certain voices. And I think that's a very valuable aspect of this legislation. And were that portion amended to remove the possibility of somebody speaking on an issue they have a conflict of interest, which I think would be a beneficial amendment, I would hope that that additional aspect of providing a right to public debate be maintained. And I want to speak about this specifically as relates to House Rule 10b, which is a rule that the Senate doesn't have, and it says that members cannot question the integrity of other members or impugn motives or question motives. And this is somewhat unusual rule to have. At the national level, for instance, the Democratic leader of our party in the Senate, Harry Reid, has repeatedly drawn a connection between campaign spending by the fossil fuel industry, specifically the Koch brothers, and certain policies that the Republican Party has advanced in the Senate. And our Senator Sheldon Whitehouse has echoed some of those concerns and has specifically impugned individual companies, arguing, in fact, that Exxon is guilty of felony violations. So I think it is valuable to have members be able to question the motives or to point out potential areas of misconduct or poor motives. And I think that having a restriction in there in the Constitution that would allow a guaranteed right to public debate would have a beneficial effect in preventing rules that unduly quash debate. And one additional aspect of this House rule is that it's been interpreted rather broadly to prevent speech not germane to a particular bill, and is often used to cut off particular members and prevent them from saying particular things. And having a right to full debate would be useful. And it's not clear in the language whether that would specifically violate that provision, but it is useful for the Supreme Court, I think, to be able to find if there were an instance where a rule were unduly restrictive, to be able to prevent such things. So I think that's a very valuable aspect. I hope that if this bill's amendment, that be maintained in there. And a second point I want to bring up relates to the question of whether, and I think I'm very pleased to see a lot of support for overall, the idea of the ethics amendment overall on this committee, whether the Senate should bring this forward for a vote even if there's no previous approval of the House. And I want to urge the Senate to take its leadership role as the upper chamber to make a statement even if approval is not preordained in the lower chamber. I think it's important for the upper chamber to often take a leadership role in saying the direction of policy that it believes it should move in, and I think that can have a positive effect on the overall debate. I remember, for instance, in the stadium fight, the Senate President's support for the anti-stadium movement was very helpful, and I think was very crucial in our ultimate victory there. So I think it's really important that on this really important issue, the upper chamber take a leadership role in advancing a policy position, even if the lower chamber has yet to specifically agree to passage. So I want to urge the Senate to pass a version of the ethics amendment this year.
Thank you. Any questions or comments for this witness? Thank you. The next group of witnesses we'll call are Lad Meyer, Michael Ocean, Peter, it looks like McClurg, Lucy Matthew, Ray Matthew, Rhonda Kirby. We had a couple other witnesses or people who signed up to oppose or support certain legislation, but indicated that they were not interested in testifying. Is there anybody that's still here that wishes to testify? Mr. Rose, I believe your name was called earlier, so I apologize, but feel free to come up. We're hearing both 2060 and 2427. Good evening and welcome.
Thank you, Madam Chair and members of the committee. So I'm here personally to support 2060, like most of the other witnesses. And I will try not to repeat things that have been said before, although I may be disputing some things that have been said before, but there's a right to debate, so good. So the reason we're here to begin with is because there was the original provision in the Rhode Island Constitution about how the Ethics Commission would function was ruled on by the Irons Court in a ruling that I think it's fair to say is widely considered illegitimate. The public does not approve of the decision that the court reached on that. The court said it was interpreting what the public wanted, but it's pretty clear that the court made the wrong call there. So the public wants to restore the Ethics Commission's jurisdiction over the General Assembly, and that's something that you hear from all over the spectrum, all over the state. So that's the reason why we're having this debate, because the public wants to restore that the provision about the Ethics Commission's jurisdiction over the General Assembly in the form that it was assumed to be in before the Irons Court ruled. Now, I do have some concerns about the Senate Bill 2427, and one of them is actually just about a minor thing. It says that Senate Bill 2427 puts into the Constitution a rule that members of the Ethics Commission can be reappointed. Under current law, members of the Ethics Commission serve one term and cannot be reappointed. And of course, the Ethics Commission members are originally appointed by a process involving the governor and legislative officials, which are some of the people that the Ethics Commission is overseeing. I don't think it's a good idea for the Ethics Commission members to be able to be reappointed by the same people who they're in charge of overseeing, because if the Ethics Commission decides to investigate somebody who holds the power of appointment, then the members who support that may find themselves out of their chance at a second term. So for that reason alone, it seems that Senate Bill 2427 is a very bad idea, especially since that would write it into the Constitution in a way that would be very hard to change in future. So I would oppose 2427 for that reason. And it also does allow people to speak in floor debate or committee debate about matters where they have a conflict of interest without even disclosing that they have the conflict of interest. And that would be a problem. I mean, even if you think that there is something good about representatives who have a conflict of interest participating in debate, still, if they don't even disclose that they have a conflict of interest, that's clearly not the best solution. So I definitely do not like 2427 as it's written now. But going back to why we're in this situation. We're in this situation because the voters really want to have an ethics commission with jurisdiction over the General Assembly. I know that's been called a fourth branch of government. It's not a fourth branch of government. The three branches of government, the executive, legislative, and judiciary, are considered separate branches of government because in each of them in its own way makes rules for the general public. The Ethics Commission does not make rules that affect the general public. Its job is just to make sure that people who are in the government in any of the three branches do their job well. And because it doesn't impinge on the members of the public, it can't be reasonably considered a separate branch of government. It does follow some separation of powers principles in being, as far as possible, isolated from the influence of people in other branches, but it that doesn't make it a fourth branch of government because it doesn't govern the people. It's just trying to keep the rest of government on track, and that's something that the public very much wanted. That's why the public put it into the Constitution, but that was not the voters asking for a fourth branch of government, which they don't want. They were just asking for a body that would keep the existing people in government on track. So that's important to remember. The Ethics Commission is trying to keep on track the elected officials, the people in government, and not trying to govern the people. Now, that is actually relevant to this issue of the jury trial that's come up. And I'm sure this is going to earn me some interruptions or at least some questions from Senator Conley, but that's okay. But it is related to the issue of the jury trial that's come up because the Ethics Commission is actually regulating only members of one profession. It's regulating people who are in government. And people who are in one profession do often have a body that regulates them and can impose penalties on them. One classic example of this is the judiciary. If a judge commits misconduct, then it's a federal judge or whatever, that judge is subject to oversight by higher judges, and the judge does not have the right to demand a jury trial de novo. Because being a judge is an honored and respected profession with its own privilege and its important place in society, being a judge means that you should be able to be subject to special oversight that's designed for that profession, and you can't claim that you can't claim as a judge that I'm entitled to a jury trial because that's my right as an American citizen, because you're not being regulated as a citizen. You're being regulated by the special rules that apply to you in virtue of you being part of the select profession that's important in society. And it's true. That's true not just for judges. It's true for other professions as well. It is true that a judge could feel frustrated that they're subject to rebukes from higher courts, they're subject to penalties from higher courts, and the judge might say, I don't want the stigma of that. I don't want to be subject to that stigma without getting a jury trial. Well, the problem is if you want to be part of this respected profession, part of that is being held to high standards that the public as a whole is not held to, and there may be a stigma that you can be subject to without going through the same regular criminal process as other people, because it's not talking about being charged with a crime, it's talking about upholding the special standards that this profession needs to follow. In fact, if a judge did complain that they don't want to be subject to this stigma without having the right to a jury trial, I would say that judge has not yet fully understood the special standards that apply to them in their place in society. And maybe you think this is a stretch, but I think that I think we should see the role of elected officials in the same way, that they are subject to stigmas if they are thought to do something wrong, and the process for them may be separate from the process from other people because it's just a question of imposing a particular set of standards on them. And I would even say that as laws have developed in this respect, we may have found that some things that perhaps were charged criminally in the past were better seen as matters of upholding a special professional standard for important professions, and that when they're covered in that way and dealt with in that way, it's not really a criminal matter anymore. This concept of special professional standards is more of a new development. So that I'm not a lawyer, but these are the counter arguments that could be made to Senator Connolly's arguments, or at least a start of them. I want to say why this jury trial provision has aroused such concern. It is true that people in the public do feel well about the idea of trial by jury. It is an important part of American values, at least when people are charged with crimes or with certain lawsuits. But the problem with a trial by jury is, in a trial by jury, the jury is not in control. The judge often makes key decisions. We heard about that before with Governor DePrete. What the Ethics Commission decided was brought to a court, and the judge decided to set aside one count there. And that can happen whenever you have a trial by jury. There's the opportunity for the judge to say, no, this should not be charged, and dismiss it for various reasons. That's what the public's concerned about, I think. I don't think the public is so concerned about a jury finding in favor of the accused. I think the public is concerned about a judge finding a reason to dismiss charges, and it's and even though it's described as trial by jury, I think people are worried about that because people realize that leaves a lot of role for judges to step in, which was, let me repeat, was not the intention of the voters when they originally designed the Ethics Commission and gave it jurisdiction over the General Assembly. So basically, we have right now, because of that Irons decision, we're in this difficult situation where the official law says that the Ethics Commission does not have jurisdiction over speech and debate, but the public sees that as illegitimate, and the public thinks what will be legitimate is to go back to the Ethics Commission having jurisdiction over speech and debate. And when you have that split like that, where the public thinks one thing is legitimate but another thing is on the books, then it often isn't received that well to try to make a compromise, something in between, because the public just wants to go back to what it originally passed in 1986, and for that reason, it's. I think it's hard for a lot of people to say, we're going to grant you this trial by jury thing that judges and other professions don't have, because they really feel that that's important for elected officials to keep to high standards. A lot of elected officials do, but they want to make sure that there is a special procedure to make sure that they do that. And that's why the Ethics Commission was created, not as a fourth branch of government, but just to keep the government on track, which there's a crying need for. So I just want to close with one thought. There was a little talk about maybe combining these two bills, 2060 and 2427. You may be surprised, but I think that might be a good idea, but I'm going to say it in a different sense than you might expect. The public really wants a chance, I think, to go back to having laws on the books that undo the Irons decision completely, that allow the Ethics Commission to have full jurisdiction over speech and debate, and that's what 2060 does. But what you could do is you could make a single resolution that combines 2060 and 2427 into one bill, and that resolution puts two constitutional amendments on the ballot and lets the voters choose. That's legal, and it has to be done as one package because you don't want one house to pass just one of them and not the other. But if you do it as just one package and as a single bill, that makes sure that you can only go on the ballot if both houses agree on this package of two constitutional amendments and putting them both on the ballot. That lets the public have a choice, and then the public can decide. Do we want to go back to what we had originally with 2060, or do we want to accept this modified version, 2427, and there's a chance to have public debate over the course of the election campaign and make a case for that. And that would respect what the public wants. I think it's key to respect the public here, and if you offer them a choice like that and try to make the case for them, I think you'd have hardly anyone complaining about this. But it's you do have to make a case for it. And let me just stress, by the way, that if you really believe that the U.S. Constitution gives you the right to a jury trial, no matter what, even for things like the Ethics Commission that regulate just one particular profession, then, okay, you can go ahead and pass 2060, and then as soon as a case comes up, it's naturally going to go into court, and the court has the opportunity, the Rhode Island Supreme Court or the U.S. Supreme Court or whatever has the opportunity 2060 to rule that you're entitled to a jury trial. But the public isn't convinced yet, so the public isn't willing to concede that point. And if you want, you can respect what the public wants, just undo the Irons decision completely with 2060, and then let the courts have a chance to weigh in on whether you're constitutionally entitled to a jury trial, because if you believe it's constitutionally entitled, the courts have a chance to read that in there. But the essential thing is to respect what the public wants by putting 2060 on the ballot, so that's how I interpret this. And I'd be happy to answer questions. Thank you.
Senator Metz.
Not so much to Randall, but just for the my perception of the whole evening of the testimony. I often give things from a different perspective based on who I represent. And people are talking about the perception of Rhode Island and what's unethical. Well, for me, parts of my district has unemployment 30%. I heard no one up here crying about it. Incarceration rates. No one up here except for me and a few other people said anything about it. Suspension rates of even kids in school, minority kids in school, no one said anything about it. So when we start talking about things that are unethical, let's look at everything in Rhode Island. Now, so equal opportunity is when we start talking about different things. So for me, my grandfather, father, poor family, humble family. But one thing they taught me, the only thing you have is your name. And so for me, that I'm not a lawyer. I'm a retired educator. So defending my name, whether it's by jury trial, is very, very important to me. But I think in this whole debate, even going back to 1986, we have lost, we can't see the forest for the trees. We have lost sight of the progress that the General Assembly has made over the years. I've been here 26 years. I was in the House for 14 years. I got out for 4, and then the people in the neighborhood talked me into coming back because they wanted me to run for the Senate. And back then, early 80s, the salary was $300 a year, and if you was in 8 years, you got a pension. Well, they did away with that. Talk about people can't testify. The sessions used to start at 2 o'clock. Well, they stopped that and did it at 4 so that we could have more people be able to participate, because by the time we got out of session, it'd be evening and people would be home from work and they could testify. I remember the last days of the session, 6, 7 o'clock in the morning, where you were so tired and you couldn't vote. You didn't know what you was voting on, and that's when they would slip all the pension bills through. Meeting notices, what meeting notices? Committee chairs. The committee chairs have more power than when I first came in, because before everything was controlled by a few. So you talk about stereotypes. So why the heck would a guy like me get into politics? I certainly don't want to be called a crook. So when I'm out there, I let people know that I'm a deacon too. So I don't go for the stereotypes. And so what I would say to the people that are so negative about their own state, and if you listen to the business, to some of the business people, when we had our Senate Economic Summits, one gentleman came in that had this manufacturing company, high tech. He said, you people have a wonderful state. He said, you're your own worst enemies. He said, there's some things that you need to improve, but you're so busy trashing one another. So for me, well, they used to say, well, how come you're not afraid of horror movies when I was a kid? Well, that's because of discrimination. They didn't have any black actors, so I didn't see the monsters attacking black people. But I'm saying that. So I would say to people, well, why am I'm up here? And I understand it. There's a lot of good people that don't want to run for office. I understand. I was one of them. My friends talked me into it. Charles Walton, the first African American senator of the state, he talked me into it. Tommy O'Connor, the city councilman, and some of my friends, because you have to get involved. If you think the Rhode Island government is so corrupt and you sit back and all you do is criticize, and shame on you, there's a saying from the 60s, if you're not part of the solution, you're part of the problem. So I would say for people, if you don't like what's going on in Rhode Island government, then run for office. I don't have the money that some of my colleagues have. It was years of community service, and the people of my district, that's why I've been here 26 years, they trust me. So they may hate the General Assembly, but in each of our districts, the people love us. And now bragging, I get 98% of the vote. It dropped a little bit. I got 92 the last time. But I would say get involved because I'm just so tired of stereotypes. I've had to fight stereotypes all my life. And now you come up here, now I got to fight the stereotype of being an elected official. It's ridiculous. Because most of the people up here are good people. Go after the ones. I signed both bills. I signed Senator Sheehan's bill, and I'm happy that he let me be one of the top 5. And I signed Senator O'Neill's bill because we do need to make some changes. But for some people that want to trash their own state, I'm going to ask you to look at the ethics. You want to look at ethics? Look at it across the board. Look at the achievement gaps in the minority community. Look at the 30% unemployment that's in some parts of my district. Look at the unemployment rates, the suspension rates, and let's talk about ethics across the board. Let's talk about ethics across the board because to leave certain populations, Matthew 25, what you do for the least. I was hungry, you fed me. I was naked, you clothed me. I was sick, you visited me. I was in prison, and you came unto me. I go to the prison on Sunday mornings. Only 2 Sundays a month now. I used to go every Sunday. So it's what we do for other people. We have to get back to some old principles and about love and different things like that. Because if we don't as a state, and if we keep this negative, and this bill is only part of it, but I want you to look at the whole history of Rhode Island, just the time that I've been here, 1984. There's been a lot of changes to make this more transparent. And we have totally lost sight. Now, that doesn't say that there isn't more progress that has to be made, but we have totally lost sight of the progress that has been made. And that's very troubling to me. So yes, let's look at the things we need to improve, but don't forget where we came from. We came a long way since the time that I've been in this General Assembly. And so the old man, I'm getting close. I don't know how much longer I'm going to go on. I have to tell people you're going to have to find somebody else.
Got a lot of work to do.
Yeah. Well, I'm just saying, but I just don't want people to walk away from the hearing on this bill and not lose. Yes, there's work to be done, but don't lose sight of the progress of where we came from. Don't lose sight of where we came from, because I remember those days of being here at 6 o'clock, 7 o'clock in the morning, the last night of the session, and you was pushing that button. You're so tired, and then pension special bills used to go through, and we stopped all of that. So there's been a lot of progress. Yes, more has to be done, but in closing, I'll just say that I'm for. The only thing I have is my name. When they look at me, and I don't like people calling me a politician. I'm a public servant. I serve my district. So when they look at me, politician, I say, no, deacon, I can hold that title a little bit longer. So let's not be so negative about our state. There's a lot of things we have to improve, but there's also a lot of good things also, and let's work on that too. Thank you. I'm sorry.
Thank you, Senator Metz. Senator Conley, briefly.
Yes, Madam Chair. I just wanted to follow up on Senator Metz's remarks because we do have a self-esteem problem, and quite often we are our own worst enemies. And frankly, I was disappointed tonight when Mr. Gramitz pulled out a study from the Center for Public Integrity to tell us that we have an ethics blind spot in Rhode Island. I'm going to disagree with it. And I won't go through it because of the time, but I'm going to ask my colleagues to look at behind tab 4 of what I provided to you tonight. Now, I'm not the Senator for Public Integrity, although I think we have a lot of public integrity. I did an analysis of ethics commissions across the nation based on 4 characteristics, because I think these 4 characteristics indicate to us the strength of ethics in Rhode Island. And that Center for Public Integrity is dead wrong. I compared ethics commissions across the nation based on whether or not it was mandated by the Constitution. Why is that important? because it's mandated by the Constitution. It places the Ethics Commission above the reach of legislation. Whether or not it was independent, meaning whether or not it stood on its own as an independent agency or whether it was a branch of the executive, judicial, or legislative government. Whether or not it had rulemaking authority, absolutely critical, because in Rhode Island especially, regulations have the authority of law. So they have rulemaking authority and enforcement and prosecution. And I've already talked about that we have enforcement and prosecution in it. What the analysis will show you when you look at the spreadsheet is that we are the only ethics commission in the Republic that has all four of those important characteristics. The only one in the Republic. Now, that data is it's current as of November. I did that analysis in November, and the underlying primary and secondary sources that I relied on had some various dates in them. But we care about ethics in Rhode Island. We have one of the strongest ethics commissions. And then I'm going to ask you to look at one other factoid. Besides those comparisons of those four qualities, you can see that I identified some other characteristics I thought were important. But look at the per capita expenditure. Rhode Island pays for ethics enforcement, for how do we value ethics? You know the old saying, what's important to you? Look at your budget. How do we value ethics? We pay per capita, our expenditure is $1.24. We far surpass, with the exception of one other, and I'll identify it, but the majority of the other states, their per capita expenditure on ethics, 14 cents, 39 cents, 23 cents. We far surpass all of them, except one other state. One other state beats everybody by a long shot, and that's Arkansas at $1.83. And I guess they need to spend a lot more there. But when you look at what do we value, we have one of the strongest ethics commissions in the Republic, based on the four characteristics of authority and power to enforce ethics, and we fund it at a rate far superior to just about every other state in the Union, with the exception of Arkansas. So I don't agree with the Center for Public Integrity. I believe that Rhode Island is an ethical state by the fact, not to say that individuals don't engage in transgressions, but it's an ethical state based on how we value ethics and how we pay for it and how we structure our commission. Just want to end on a positive note.
Thank you, Senator. Any other comments on this legislation? At this time, Senator Nesselbush moves that we hold Senate Bill 2060 and 2427 for further study, seconded by Senator Metz. All those in favor signify by saying aye. Aye. Opposed? Those are held for further study. The next bills we're going to do are Senator Raptakis's bill, Bill 2304, and Senator O'Neill's bill 2362. So, Senator O'Neill, if you'd like to come forward. Also, John Marion and Ken Block. Senator Raptakis, why don't we start with you if you'd like to endeavor to explain.
Sure. Thank you, Madam Chair, members of the committee. This bill allows the public to vote on to amend the Constitution for a line-item veto. And many of you heard in the last few weeks that Rhode Island is one of the only states that does not have or allow the governor to have a line-item veto. 44 other states do. And basically, there should be no fear. The General Assembly already can veto, the governor can veto any bill, and the General Assembly can override that bill. If the governor vetoes the budget, the General Assembly can override the budget. And what this bill does, it allows, if the governor overrides a budget article,
the General Assembly can override that budget article in the budget. So we're not losing any jurisdiction or any authority. This just adds another entity, part of the budget, a budget article, that the governor, if he or she wishes to veto, the General Assembly still has the authority to override that veto and continue the process of government here in Rhode Island. Thank you.
Thank you. Senator O'Neill, why don't you explain your bill, and then we'll go on to the witnesses.
Thank you, Madam Chairman and members of the committee. My bill is basically the same as Senator Raptakis. We actually put them in independently without knowledge of each other. But that's fine. Great minds think alike, and we certainly want to join the other 44 states that do have this power, the governor's power to veto something within the budget, not the whole budget, but if there's something particularly onerous. And given the numbers in the General Assembly, I'm sure if it was objectionable, the Senate and the House would quickly override that veto anyway. But I think it's good procedural law, and I think that it could be helpful to future generations, because we don't know what the composition of the House and the Senate will be 10 years or 20 years from now. And I think to give the governor that opportunity to take something out of the budget, yet approve the whole budget, really would cause an expediting of the process. So I'll let the couple of other people who have been kind enough to stay here this long and endure this discussion on the ethics bill. I thank them both very much, and I look forward to their comments. Thank you all.
Any questions or comments for Senator O'Neill? Mr. Marion, why don't we start with you?
Sure. Thank you, Senator. I'll be brief. I want to thank Senator Raptakis and Senator O'Neill for putting this in. I think this is a good time for this. Ken will probably talk a little more. There's been some public opinion polling done in the state by a reputable pollster from Fleming and Associates, who's found, I believe it's 72% of Rhode Islanders support the idea of a line item veto. I just want to talk about one reason why I support this, and it's something from my own experience, which is we're talking about the ability to line item veto something in the state budget. And you all know, because you've all lived through budgets, that the budget is the most important document that comes out of the General Assembly every year. It spends $6 billion. It makes literally thousands of policy decisions as well as fiscal decisions in there. And it's subject to months and months of hearings before the Senate and the House Finance Committee. The governor's budget it's really well vetted by both the fiscal staffs. But then it gets to the floor and changes happen. And sometimes those changes aren't vetted. Those changes are just voted. And I'll give one example. I was here in 2012 when, in June of 2012, the House of Representatives decided in haste to merge the state boards of education. That is, and they did it with some fiscal impact in order to put it in the budget. That is the most consequential, probably, education policy decision I've seen in 8 years. And it was done without a single hearing because it was done as an amendment to the budget. And Governor Chafee faced a choice. Does he veto the entire budget because of this one change, or does he let it go? And he chose to let it go. And we saw the House and Senate have to come back 2 years later and redo that and put them back together, although in a somewhat different form with the two councils. And I think that makes just a great argument that had the line item veto existed, I would guess the governor would have vetoed it. The House and the Senate, as it was said, could have come back and overrode those, but it would have clarified that issue, right? That one issue that was terribly important to every person from pre-K to postgraduate education in the state of Rhode Island who are governed by that. And so I think the line item veto can be very, very valuable when it comes to issues like that. But you can go back in history and look at items that were put in at the last minute without a public hearing that could be singled out this way, and could get then the public attention that they deserve that they didn't get as part of the regular process. So for that reason, we support the idea of a line item veto. Thank you.
Thank you. Any questions or comments for Mr. Marion? Senator Metz.
Yeah, John, just some of us are trying to undo the cuts to RIPTA for the handicapped people who went from $1, now it's they did away with it, and I think they put back 50 cents, but some of us are trying to undo that. So for me, as I weigh the merits of the line item veto, what I'm trying to figure out as it relates to the social safety network and cuts like that one I just mentioned, where, for my constituents, where would I have more influence? Would I have more influence with the governor and his or her staff, or would I have more influence with the assembly leaders as I endeavor to look out for the interests of my constituents? So I just wanted to share that with you because that's what I'm wrestling with.
Yeah,
right now.
no, I think that's a really good thing to think about. And there's 2 points there. Is one, the social safety net has taken cuts at the last minute. So in 2011, there was, I think, a $24 or $28 million cut for services for the developmentally disabled. Again, no public hearing. It occurred as a floor amendment on the House of Representatives. I'm not blaming it all on the House just because I'm in the Senate. But that's where the vast majority, as you know, of the floor amending of the budget happens. The budget, goes to the House first, and they tend to spend more time on the floor with it. And so I don't think there is an answer to your question. There is some interesting research about whether states with line item veto power, and depending on the flavor of the line item veto, tend to spend less. And I think the data is inconclusive from my reading of a couple of the academic papers. So this isn't necessarily about if we have a line item veto, we will have a smaller than $6 billion budget. I don't think the data bear that out. What I think it is it's about, giving the governor the power to single out some items in the budget for a veto and not have it veto the entire thing. But that's a great question.
Any other questions or comments for Mr. Marion? Mr. Block?
Thank you.
Thank you. Your stamina is really admirable. Thank you. So 44 out of 50 states have a governor's line item veto. And one of the words that's being bantied around a lot this year is outlier. Rhode Island shouldn't be an outlier relative to the rest of the country. We hear this in terms of our economic standing. We hear this in terms of the quality of our roads. We hear this in many different ways. We are a serious outlier when it comes to the lack of a line item veto for our governor. While John and I on good government issues are usually really in sync, I last year presented an academic paper from Dr. I still can't say this person's name, Magalhães is the best I can do, and it's totally mangled. But I submitted that as part of my testimony last year, and the findings in that paper said that from this doctor's perspective, he determined that states with a light item veto did control spending more effectively than states that didn't have it. And I didn't bring it with me this time. If you want, I can dig it back up and send it in. But it was submitted last year as part of the testimony. The line item veto is important because it brings the only statewide elected official into the budget debate and helps to balance the power in the debate and the push and pull in the crafting of the budget, where the light item veto has a serious impact in the states that have it is once the governor's budget has been presented and once it's modified in the General Assembly, as John said earlier, currently Rhode Island's governor can only veto, approve, or allow to pass without a signature, which is just a symbolic protest, right? With the light item veto and with the striking of one or more individual elements in a budget, Now what you have is a much more open and transparent process, because the specific issue that's in debate, the specific line item that was struck, can absolutely be overridden. And when it does get overridden, it does so with a vote of the entire General Assembly to override the veto. And I think that's really important, because I think we all know ultimately that the majority of light items that are struck are ultimately approved, and I think studies show across the states that not a lot of struck light items remain struck. But what it does is it fosters debate, and it actually forces a vote. And I think that going on the record for whatever the issue happens to be is important, because it's one thing to bury something in a budget, it gets passed in a flurry of late-night activity, and there's no real accountability for whatever that thing was. It's quite another one to say, yeah, I really know what that issue is about, and I'm casting my vote yes to keep it in there because I've thought about it and it's important. I'm going on the record for it. And I really don't see a downside in any way for Rhode Island to have a governor's light item veto. I think we all win across the board by having it. It gives us a more accountable system. It gives us a more transparent system. And at the end of the day, it makes us look like the vast majority of all of the states that are doing it, and in my opinion, that makes a very good thing here in particular. One last point, and I'll close. I don't see it as negative or negativity to advocate for something like a light item veto where we don't have it. I think it's important to question the status quo, and it's important to advocate for things that you believe can make the state better. And I know that everybody who was here tonight was actively trying to make the state better by their presence. They weren't here to be negative. They were here to express whatever their particular positions were in relation to the issues that were out here. And they were here trying to be constructive for the most part and to make a difference. So I want to thank whoever's left here for having been here today, and I thank you for your time as well.
Senator Metz.
Yeah, any of the witnesses of the 44 states that were mentioned, I was just curious, was there any significance as far as was the governor one party and the assembly another party? How did that all work out of curiosity?
Yeah, I think in Massachusetts, Governor Weld, I remember one year vetoed something like 900 individual light items, and I think like 5 of them remained vetoed when he was said and done. I think that's a very extreme and unlikely scenario by and large. In most circumstances, I think that a governor would wield the veto pen as carefully as they use it with legislation. You don't typically see it heavily used because, let's face it, at the end of the day, the branches of government work better when they're working cooperatively than when they're at loggerheads. So,
thank you. Any other questions or comments, Mr. Block? Thank you. The next witnesses we'll call are Phil West and Ladd Meyer. Mr. West, welcome again.
Thank you very much, Madam Chair. Let's see. Now it's on. Thank you very much, Madam Chair, and I want to say a word of thanks to Senator Reptakis and Senator O'Neill for introducing this bill. For years, and I'm glad Common Cause has embraced it. For years, I thought it was necessary, but the Common Cause Board did not approve it, and so I'm glad it's there now. I'm going to be very brief, unlike some of you may not believe that, but I'm going to be very brief, and I want to share just 3
very careful, Mr. West. Only going for a half hour.
I want to give you just a couple of examples. One of the most of you as members of the Senate have not sat in on the process of the budget unveiling on the House side. I've sat on it over there many times, and what happens is that they have debated the budget and a whole lot of stuff all through the year, and then on the night that the budget comes out, they also come in with a bunch of budget articles that get added on, often without any debate. In 1997, one of those budget articles was for the Underground Storage Tank Fund Board. The governor had asked for 150 to raise the administrative costs for the underground storage tank fund from 125 to 150,000. And they Representative Mazzarone came in with a budget article. He was Deputy House Majority Whip at the time, I believe, to raise it from $125,000 to $550,000. Notice the size of that increase. And the House approved it. It came over to the Senate. Senator Mike Linehan was chair of the Senate Finance Committee. He was furious because he hadn't seen it before. The House broke the deal with the Senate that they would let them know. And so he was upset, and he took it to Senate Majority Leader Paul Kelly. And Paul Kelly said, we're stuck. We can't do anything about this. I wasn't in the conversation. He shared that with me for the first time when I interviewed him for my book. Ironically, so it went through. The next year, precisely the same thing happened again. No hearings on the Underground Storage Tank Fund board. And the budget article came in at the last minute, and it proposed the increase to $550,000 again. In other words, the governor put in for the lower amount, asked for a modest raise, and so they were going to do it again. Senator Mike Linehan, to his credit, and this has never been said publicly as far as I know, he sat down with Senator Paul Kelly, the majority leader, and he said to him, Paul, if you make this go through, you have my chairmanship. I will resign, and I will tell people what this is about. And at that point, Senator Kelly turned around and went back to the House leadership, and they cut it back in 1998 to $350,000. So they split the difference. But I would simply point out that that's there's a way that a huge amount of money was going for some, I think, very questionable purposes. And the quiet courage of one senator stopped some of the waste that was there. In the 2002, there was a budget article regarding the tobacco settlement proceeds. And this has been discussed at various levels, and I'm just going to summarize what it amounted to. The Tobacco Settlement Financing Corporation Act got rammed in, completely different from where it had started. Sheldon Whitehouse is the Attorney General. Lincoln Almond is the governor. Both blasted it, but they couldn't do anything about it. And so as a result of that tobacco settlement money has gone off. Who knows where it's gone? But I would go especially to Senator Metz's comment before in terms of the effect on low-income communities, because so often people get hooked on cigarettes, and it wiped out the possibility of an education program. I think in all three of those cases that I've mentioned, had there been a line item veto, Governor Almond would have vetoed those lines, and once the issue became clear, those vetoes would have been sustained. I'm not sure they would have been, but I think the argument is simply that the governor then has the ability to say to legislative leaders, don't even do that outrage. You know, and as Senator Metz said before, so often at 6 o'clock in the morning, you're voting on things, and that's less now than it used to be, I think. But that's when the worst abuses came. The governor's staff can see it. They ought to have the chance to do a line item veto. Let's join the other 44 states that do it. So thank you, Senator Reptakis. Thank you, Senator O'Neill. I'll be glad to answer any questions.
Thank you. Any questions or comments for Mr. West? Thank you. Is anyone here else here to testify on either of these bills? Senator Nesselbush moves to hold Senate Bill 2304 and I'm looking, I don't see it. 2362. Thank you. It's late. I apologize. For further study, seconded by Senator Lombardi. All those in favor signify by saying aye.
Aye.
Opposed? The next bill, the bill is held for further study. The next bill here is Senator Raptakis' Bill 2307. Senator Raptakis.
Thank you, Madam Chairman and ladies and gentlemen of the committee. I want everybody to grab their iPhone or notepad. And this bill here, it allows the votes that are taken to be